And now that requires judgment, and that's why in Ten Commandments cases I came out one way in one case and the other in the other. Now, it may be that that's hard to apply, which of course it is. Of course it's hard to apply. But we don't have the French system, which is 100% purist. And we don't have the British system either. And so you say it's a hard area, and so do I.
But you have resolved it by the purposive approach at its very highest level of generality, which shows you the risk of that approach. You say, obviously, the purpose of the Establishment Clause was to reduce religious controversy. And therefore, what it means is whatever reduces religious controversy is required by the Establishment Clause. I mean, that was its purpose, but it didn't say achieve that purpose by any means. It has a text. And it seems to me you have to say, yeah, that was the purpose of the text, but that doesn't mean that anything else which achieves that purpose is therefore required by it.
Do you remember you used to have a thing in logic classic called CDNF, conclusion does not follow? The fact that you sometimes...
I never took a logic class. I'm sorry.
Ah, we're making progress. The point I wanted to make is that sometimes, and that's why Ten Commandments case was hard, but I wouldn't retreat from that at all. I mean, I felt that, but the other one's hard too. But there can come up occasional cases, occasional, and they are occasional, where there just is not going to be an answer unless you go back to that basic purpose. And sometimes you'll have to do it in a general way. And that, in that case, but not in every case, far from it, in that case, I thought that the display of the Ten Commandments in Kentucky, which involved a kind of deliberate thing to get religion into that courthouse, was in fact prohibited, in part because of the circumstances which I set out. But I also thought that the tablets of the Ten Commandments, which had been put in the state fairground, or the state capitol ground in Texas, with a lot of other non-religious monuments, and it happened to be put there, those tablets, because of Cecil B. DeMille's movie, The Ten Commandments, where he had given money to a secular civic organization called the Eagles to spread the Ten Commandments monuments throughout the country. He thought it would be a good publicity for his film. That's quite true, apparently. And they'd been there for 45 years. And what I said in the opinion is nobody had ever objected. It was there for with other monuments to show the history of the ideals of the Texans. It went there really for a secular purpose and not for a religious purpose. And I thought ultimately it would be very disruptive of the value that underlies that Establishment Clause, either to say that both of these monuments, very different circumstances, were constitutional, or to say that both were unconstitutional. And I did look to the value, and I reached agreement on the court in that I was the only one who thought that way. And so I grant you that is not on its face a sign that I was right. But nonetheless, I wrote down the reasons, and that is an instance of having to refer back to the basic purpose underlying the clause.
Listen, I was glad to have you come out right in one of the two.
We've got some questions from the audience, and this follows up on our conversation now for Justice Scalia. If one cannot discern the purpose of a modern Congress, can one discern the will of the framers? Aren't those who focus on the intent of the founders simply imposing their own subjective view of history?
Well, you never heard me mention the phrase "intent of the founders." I don't do that. I take the text of the Constitution and I ask, what was it understood to mean by the society that adopted it? And that is very easy to figure out. It is easy as pie to figure out that the Cruel and Unusual Punishments Clause was not understood to prohibit the death penalty, that the Due Process Clause was not understood to forbid laws against abortion, and so forth. You look at the state of the laws. which existed at the time and continued to exist with no one claiming that they violated the Constitution. That is conclusive evidence of what the society that adopted the Bill of Rights believed it meant.
Justice Breyer, you say in your book that Supreme Court justices should interpret the Constitution pragmatically in a way that enhances our democratic system of governance. Should district court and court of appeals judges interpret old Supreme Court precedents like Roe versus Wade pragmatically and in a way that enhances the functioning of our democracy?
Pragmatism is a dangerous word because it means to people often just do whatever sort of good and works at the moment, and that isn't how I mean it. I mean, there is a tradition philosophically in America called pragmatism, which has roots back to William James and Peirce and others, and it's a tradition where you can have rules, you can have moral rules, you can have other kinds of rules, and you have to follow them. But if you look at the object of the system as a whole, or you look to the purposes of any subset of rules, they have purposes, and you look at that pragmatically. And that's what I'm thinking of. I mean, when sometimes I'll say, for example, and I'll say it in imagination, but sometimes I'll say it in audience because it puts the thing in a sort of lively way. I say, well, we have a document, the Constitution of the United States, that was intended to be more than an exercise in logic. It was intended to be more than a set of words. It was intended to be a set of words that worked to make this country governable. And I said that right there. I signed an opinion in the affirmative action case in Grutter that I thought was saying that. It was saying that the country has to work, and it's complicated how it works out there. But I say if there are interpretations of the Equal Protection Clause, and there are different ones, and I thought that I have one favored and what I wrote about, and I thought one of the virtues of that is it would help bring our society together, and that was part of the purpose of that amendment, and that amendment had to do with a Constitution that was going to work for people in the United States. And then I imagine James Madison is here, and I say, James, I can be quite familiar with him as long as he's not actually here. Do you want an interpretation of an important part of that Constitution that will, in fact, work in terms of bringing people together and to try to achieve a goal, or do you want one that isn't going to work? Well, since he's not here, I can answer the question for him. You see, I want one that's going to work and not work. Well, I'm not going into the merits of that particular case.
You don't know James Madison. I know James Madison.
Well, I know James Madison in my imagination, and forget that. The point is that in particular clauses and particular purposes and particular ways in which things work out is what I mean by a pragmatic approach towards the Constitution. It isn't just sitting there generally and asking what's good and what isn't good. Ten Commandment cases are a good example because note how I tried to bring it back to the purpose of the clause in terms of what will work to achieve that purpose, not just saying what's good for the country in general.
Could you respond to that, Justice Scalia?
No. No, it did not provoke anything from me, so I'll just let it. So many of the things he does say do provoke. Then I'll let this one go.
All right. Well, we have one for both of you. What do you think of the political term activist judge? Does it apply to judges on both sides of the aisle or just so-called liberal justices?
No, it's an insult. I mean, when people use it, they mean it as an insult. They mean it as a judge who's substituting his own opinion for what the Constitution requires. And no one wants really serious. Sometimes people might say, I'm an activist judge, but they're doing it in quotation marks in an ironic way. And the point that I try to make in the book is no one needs activist judges, and no one tries to be an activist judge, though we do try to apply different, sometimes, approaches to the Constitution. Right? And